religions. Hopefully, prayerfully, together, we can aspire to a common purpose to bring enduring peace to the birthplace of that heritage. Mr. President, I yield the floor.
Mr. President.
Senator from Montana.
Thank you, Mr. President. Today, Mr. President, we have an opportunity to do away with a law that tramples on our constitutional rights, a law that invades the privacy of law-abiding Montanans and Americans, a law that deprives Americans some of our most basic constitutional protections. This week, we are voting on whether to extend the USA Patriot Act 4 more years as is. And there's a chance that we may not have an opportunity to change it, even though we know that our freedoms have been compromised. And that is a shame, because without that possibility, we're not having the debate the American people deserve. If our only choice is to vote yes or no, I'm going to vote no. Long before I ever got to the Senate, the Patriot Act was sold to us as a toolbox of sorts, to give U.S. agents the tools they need to find and fight and kill terrorists. What we got from the Patriot Act was a law that is killing the rights guaranteed by our Constitution. It gives our government full authority to dig through your private records or tap your phones or make a case against you without even having a judge's warrant, even if you're doing nothing wrong. We give up our rights, Mr. President. We give way to exactly what the terrorists wanted for us, fewer freedoms and invasion of privacy. It's not acceptable in Montana, and I'm sure it's not acceptable anywhere else. More than 200 years ago, one of our founders of this country warned us, and here's what he said: those who give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Words of wisdom from Benjamin Franklin. Our nation was founded on the principles of freedom and privacy and a government that we control, and we got exactly the opposite with the Patriot Act. Mr. President, here's a copy of the Constitution. It's a reminder of our rights as Americans guaranteed by the Fourth Amendment. And I quote, "The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." The folks who wrote the Patriot Act were here in Washington long before I even thought about running for the U.S. Senate. But you do not have to be a lawyer to know that the Patriot Act flies in the face of the Fourth Amendment. It allows the government to conduct secret proceedings, even when those proceedings don't need to be held in secret. And if we allow that to happen, we toss government transparency and accountability out the window. As we've seen over the past few weeks, our military forces and intelligence agents are the most effective in the world. They are the best because they have the most powerful tools in the world to do their jobs. They are better trained than anyone else. They're stronger, they're smarter, and they do what they do without needing to snoop around in the private lives of law-abiding Americans and Montanans. Without having to dig up your medical records or your gun records or your library records or your Internet records, Mr. President, the Patriot Act is bad policy that has put us on a very slippery slope. Our constitutional freedoms are too valuable to give even an inch of them away, especially when we don't need to. And without the opportunity to make real changes to this bill, our only option is to say yes or no to extending this law 4 more years. If we do, an entire decade will have passed without the opportunity to make any adjustments. Not having the opportunity to amend the Patriot Act, I'm going to vote against it in the name of freedom and privacy. And I urge all my colleagues to do the same because it's the responsible thing to do. With that, Mr. President, I yield the floor. And, suggest the absence of...
Clerk will call the roll.
Mr. Akaka.
Suggest the absence of quorum and ask that the time be evenly divided.
Without objection, and clerk will call the roll.
Mr. Akaka. These three provisions are roving wiretaps, Section 215 business record orders, and the lone wolf provisions. These are all very important tools used to investigate and prevent terrorist attacks. They have been reauthorized a number of times, but it seems that in recent years we've been discussing only very short-term extensions of these critical tools. That is why I will support the cloture petition on moving to S-1038 today. This legislation provides a 4-year extension of the 3 expiring provisions without any substantive changes to the existing authorities, and I believe there does not need to be changes to existing authorities. Regardless of my support for today's cloture vote and support for the 4-year extension, I want my colleagues to know that I support a permanent extension of the 3 expiring provisions. Having this debate year after year offers little certainty to agents utilizing these provisions to combat terrorism. It also leads to operational uncertainty, jeopardizes collection of critical intelligence, and could lead to compliance and reporting problems if the reauthorization occurs too close to the expiration of the law, and we're getting very close to that. If we believe that these tools are necessary, and I clearly state I believe they are necessary, we need to provide some certainty as opposed to simply revisiting the law year after year. Given the indefinite threat that we face from acts of terrorism, it is my view that we should permanently reauthorize these 3 expiring provisions. This position is supported by agents on the ground using these tools every day. I have letters of support from the Federal Bureau of Investigation Agents Association supporting a permanent reauthorization of the 3 expiring provisions. The Federal Law Enforcement Officers Association also supports a permanent extension of the provisions. In fact, a very important passage of that letter states, quote, "Crimes and terrorism will not sunset and are still targeting our nation and American citizens. Just like handcuffs, the Patriot Act should be a permanent part of law enforcement arsenal." Then we have another letter from the Society of Former Special Agents of the FBI. And that letter, quote, "We urge Congress to reauthorize the expiring provisions of the Patriot Act permanently and without restrictions, as the 3 expiring provisions are essential to the security of our country." End of quote. Mr. President, I ask unanimous consent that these letters be a part of the record.
Without objection.
In addition to agents on the ground, we've heard strong support for extending the expiring provisions of the Patriot Act from members of the Bush and Obama administrations. We've heard testimony from the Director of the FBI, the Attorney General, and the Director of National Intelligence about the strong need to reauthorize these provisions. These same offices have recommended extending the provisions regardless of political ideology, as both Republican and Democrat administrations have backed the extensions. The 4-year extension we're voting on today is a step in the right direction. Extending the 3 expiring provisions without any substantive amendment that would restrict or curtail the use of these tools is very important given the recent actions that led to the death of Osama bin Laden. Now is not the time to place new restrictions and heighten evidentiary standards on critical national security tools. A lot has been said about these provisions, and unfortunately most of what has been said is incorrect. Congress enacted these provisions and reauthorized them in 2005 following the 9/11 Commission report, which criticized the way our agents failed to piece together clues. In other words, to connect the dots. Since that time, the 3 expiring provisions have provided a great deal of information to agents that have helped thwart terrorist attacks. And let's be very basic. What is terrorism about? It's about killing people living in Western Europe and North America. They don't like us. They want to kill us. And we've got to prevent that. They can make continual mistakes and not get their job done. But once the FBI makes a mistake and lets one of them get away, it's a victory for the opposition. We can't afford a failure. Now, examples along the lines that we can't have these failures. In testimony before the House Judiciary Committee, Subcommittee on Crime, Terrorism, and Homeland Security, Robert Litt, the General Counsel of the Office of the Director of National Intelligence, testified that a Section 215 order was used as part of the investigation by the FBI into Khalid al-Dawsari, who was arrested in Texas recently. It was later revealed in a criminal case that he was purchasing explosive chemicals and bomb-making components online and had scouted targets in Texas. Mr. Litt also testified that Section 215 orders were utilized to obtain hotel records in the case where a suspected spy had arranged lodging for intelligence officers. He also discussed the roving wiretap provisions and how it is used to help agents track foreign agents operating inside the United States who switch cellular phones frequently to avoid being caught. These examples are limited not because the authorities aren't valuable, but because of how sensitive the investigations are that utilize these authorities. While the need for keeping personal national security matters classified may prevent the open discussion of further examples in this setting, here on the floor of the Senate, it is important to note that these provisions are constantly under strict scrutiny by the Inspector General at the Department of Justice and by congressional oversight. In fact, in a March 2008 report, the Justice Department Inspector General examined the FBI's use of Section 215 orders and found, quote, "We did not identify any illegal use of Section 15 authority," end of quote. Further, there are no reported abuses of the roving surveillance authority, and the lone wolf provision has not yet been utilized, so it is without abuse as well. While I agree that these 3 provisions should be subject to strict scrutiny from inspectors general and Congress, that oversight authority already exists in the law and does not require amendments to these tools to achieve the goal of oversight. As such, it is important that Congress reauthorize these provisions quickly and without amendment. I urge my colleagues to vote in support of the cloture petition on motion to proceed to S-1038 because it provides a clean reauthorization of these very vital tools for 4 years without substantive changes. In other words, if it ain't broke, don't fix it. While 4 years is a far cry from the permanence that I feel is necessary on these provisions, it does provide more certainty and predictability than continuing to pass short-term extension after extension. You want to use it? Okay. I yield the floor.
Mr. President. Senator from Kentucky.
There's been a lot of discussion of the Patriot Act, and we're told basically that we wouldn't be able to capture these terrorists if we didn't give up some of our liberties, if we didn't give up some of the Fourth Amendment and allow it to be easier for the police to come into our homes. We were so frightened after 9/11 that we readily gave up these freedoms. We said, well, the Fourth Amendment's not that important. We'll just let the government look at all of our records, and we'll make it easier for the government to look at our records. The question you have to ask, though, is whether or not we would still be able to catch terrorists by using the Fourth Amendment as it was intended and having the protections of the Fourth Amendment. What you have to ask yourself is think about the worst person in your community. Think about someone accused of murder or rape or a pedophile. You think of these people. Do you know what happens if someone's accused of that? Even if it's 3 in the morning and they want to get their records or they want to go into their house, they call a judge. This is something very important. They get the warrants almost all the time, but it's one step of protection. What you have is the protection where you don't have police officers writing warrants to come into your house. You have to have it reviewed by a judge. What we've done through the Patriot Act is taken away some of the protections of the Fourth Amendment. The Fourth Amendment says you need to name the person and the place to be searched. We've taken away those protections. The Fourth Amendment says that you need to have probable cause. We've taken away those and made it to where it's if it's relevant or we think they might be related to it. Originally, the FISA court lowered the standards somewhat on the Fourth Amendment, but it recognized that it was lowering the standard and was careful. We had secret courts set up, and the FISA court was the court that dealt with things that had to do with national security or terrorism or intelligence. The information was kept secret, so we didn't let everybody in the world know the name, but the name had to be divulged to the judges. Well, those who argue that you have to have the Patriot Act or you have to do this or we will not be able to stop terrorism, they need to explain why the FISA court did tens of thousands of search warrants and never turned any down. In fact, the history before the Patriot Act was no search warrant had ever been turned down. So do we really want to give up our liberties in exchange for more security? Franklin said that those who give up their liberty in exchange for security may end up with neither. Right now, if you have a Visa bill that's over $5,000 and you choose to pay for it over the phone, which is a wire transfer, the government is probably looking at your Visa bill. They don't have to show probable cause, and they don't have to have a judge's warrant. And this does apply to U.S. citizens. Often they'll tell you, oh, it's only foreign terrorists we're looking at. They want you to feel good about allowing this spying. But this spying is going on by the tens of thousands and even by the millions. With regard to these suspicious activity reports, we've done over 4 million of them in the last 10 years. We're now doing over 1 million a year. These suspicious activity reports, all the trigger is, you don't have to have anything to do with terrorism. The trigger is just that you have over $5,000 that you've transferred by bank account. Now you say, well, the courts have decided that your bank records aren't private. Well, the hell they aren't. They should be private. My Visa records, if you look at my Visa records, you can tell whether I go to the doctor, what kind of doctor I go to. You can conceivably tell what kind of medication I'm on. You can tell what kind of magazines I read. You can tell what kind of books I order from Amazon. Do we want a government that looks at our Visa bill? Do we want a government that looks at all of our records and is finding out what our reading habits are? One of the provisions applies to library records. Do you really want the government to go and find out what you're reading at the library? We now have a president that's wanting to know where you've contributed before you do work for the government. Do we really want that kind of all-encompassing government that is looking at every record from top to bottom and invading our privacy? There's another aspect of this called national security letters. These are basically warrants that are written by FBI agents. No judge reviews them. This is specifically what James Otis was worried about when he talked about general warrants that weren't specifying the person or the place and that were written by police officers. And this is a problem because really we depend on the checks and balances in our society. We never want to give all of the authority to either one group of Congress or to the president or to police or judges. We have checks and balances to try to prevent abuse. Now, some have said, well, if you have nothing to hide, why do you care? Well, the thing is that it will not always be angels that are in charge of government. You have rules because you want to prevent the day that may occur when you get someone who takes over your government through elected office or otherwise who really is intent on using the tools of government to pry into your affairs, to snoop on what you're doing, to punish you for your political or religious beliefs. That's why we don't ever want to let the law become so expansive. But the thing is, you have to realize that you can still get terrorists. We get rapists and murderers every day by calling a judge. That's what I'm asking for. I'm asking that we go through and obey the Fourth Amendment. Many conservatives have argued that, well, they love the Second Amendment. Some liberals say, well, they love and will protect the First Amendment. But you know what? If you don't protect the entire Bill of Rights, you're not going to have any of it. If you want to protect your right to own a gun, you need to protect your gun records from the government looking at your gun records and finding out whether you've been buying a gun at a gun show. You need to protect your privacy. If you want to protect the First Amendment, you've got to have the Fourth Amendment. In fact, we specifically had to go back there. The original Patriot Act said that you couldn't even consult with your attorney. You couldn't even tell your attorney. You were gagged from telling your attorney. Even now, though, you say, why? I don't know if they've investigated me. You know why? Because they tell your phone company, if they're looking at your phone records right now or your Visa records, it's against the law for Visa or the phone company to tell you that. It's hundreds of thousands of dollars of fines and jail time. It's 5 years in jail if your phone company tells you they've been spying on you. Now, some of this doesn't even require a letter from government. Some of it is done by the banks. The suspicious activity reports, we've simply told the bank, here, anybody that deals in cash, anybody that has over a $5,000 transfer, wire transfer, or who deals in large amounts of money, the bank it's incumbent upon the bank to spy on their customers now. This is a real problem, and I think that we need to have some argument and debate in our country over these things. Some want to have these things permanently. They want to permanently give up their Fourth Amendment protections, and I disagree strongly. Not only would I let these expire, but I think we really should sunset the entire Patriot Act and protect our liberties the way it was intended by our founding fathers. James Otis was an attorney in Boston, and he wrote about these things they called in those days writs of assistance. And these were general warrants. The king would write them, or actually they were written by soldiers here. They didn't name the person to be searched or the place, and they were used as a way to have the king have his way with the people and to bully the people. The idea of general warrants is what really sorely offended our founding fathers. That's why we got the Fourth Amendment. The Fourth Amendment was the product of a decade or more of James Otis arguing cases against the British government. But the question you have to ask yourself when thinking about these issues is, it's not so simple that you can just say, well, I'm either against terrorism or I'm going to let terrorists run wild and take over the country. You can be opposed to terrorists. We can go after terrorists. We can go after murderers and rapists and people who commit crimes, but we can do it with a process that protects the innocent. You know, we looked at, I think so far they say we've looked at 28 million electronic records. We've looked at 1,600,000 text messages, and we have 800,000 hours of audio. We have so much audio that they can't even listen to it all. 25% of what they've recorded of your phone conversations is not listened to because they don't even have time to listen to it. My point would be that we're eavesdropping on so many people that it could be that we are missing out and not targeting. It's just like the airports. Every one of you is being searched in the airport, and you're not terrorists, and you're no threat to our country. Why are we not looking for the people who would attack us and spending time on those people? Why do we not go to a judge and say, this person we suspect of dealing with this terrorist group, will you give us a warrant? Why don't we have those steps? Instead, we're mining and going through millions of records, and I think we're overwhelmed so much with the records that we may well be doing less of a good job with terrorism because we're looking at everyone's records. But the bottom line is I don't want to live in a country where we give up our freedoms, our privacy. I don't want to live in a country that loses constitutional protections that protect us as individuals. We do have a right to privacy. You have a right not to have the government reading your visa bill every month. We do have rights, and we should protect these. But we shouldn't be so fearful that we say, well, I'm a good person, I don't care, just look at my records. If you do, you're setting yourself up for a day when there will be a tyranny, when there will be a despot who comes into power in the United States and uses those rules that you said, oh, well, I don't have anything to hide. What happens when someone takes over who believes that your religion is to be combated, who believes that your political beliefs and your literature should be combated? What happens when that day comes? We cannot give up our liberty. If we do, if we give up our liberty and we trade it for security, we'll have neither. So I rise in opposition to the vote on cloture. I will be introducing amendments to the Patriot Act this week, and we will be having a real debate about how we can stop terrorism but also preserve freedom at the same time. Thank you.
The senator from Iowa.
I have a unanimous consent request that Dale Eliason and James Cook, detailees on my Judiciary Committee staff, be granted 4 privileges for the remainder of the 112th Congress.
Without objection.
I yield the floor.
Mr. President.
The senator from Georgia.
Mr. President, I rise in support of invoking cloture on the motion to proceed to S-1038, the Patriot Sunsets Extension Act of 2011. In 4 days, on May 27, 3 FISA provisions, the Lone Wolf, Roving Wiretap, and Section 215 Business Records Authorities, will expire unless Congress acts to reauthorize them. The House has been working on a bill, H.R. 1800, that would make the Lone Wolf provision permanent and extend the other 2 provisions until December 2017. Senator Feinstein and Leahy have sponsored bills that would, among other things, extend all 3 provisions until December 2013. It seems to me that 1038, with its extension of the 3 sunsets until June 1, 2015, is a reasonable compromise. Although I believe that each one of these tools should be made permanent, this bill will ensure that our intelligence professionals have the tools they need to keep our nation safe. There is little disagreement that these provisions should and must be reauthorized. FBI Director Robert Mueller has testified repeatedly that each one of these provisions is important to both national security as well as criminal investigations. But their importance does not end there. Because of enhanced information sharing rules and procedures, other parts of the intelligence community, like the National Counterterrorism Center and the National Counterproliferation Center, often depend on the information collected under these provisions. Losing or changing these authorities could adversely impact the intelligence community's ability to analyze and share important national intelligence information. According to Director Mueller, with all the new technology, it is easy for a terrorist target to buy 4 or 5 cell phones, use them in quick succession, and then dump them to avoid being intercepted. He has testified that the ability to track terrorists when they do this is tremendously important. I couldn't agree more, because it's pretty obvious those guys are up to something, and it's not good. Our enemies often know our own laws better than we do. They understand the hoops and hurdles the government must clear to catch up to or stay ahead of them. Keep in mind that the FBI cannot use a roving wiretap until a court finds probable cause to believe that the target is an agent of a foreign power. Some critics claim the provision allows the FBI to avoid meeting probable cause as surveillance moves from phone to phone. This claim is simply not accurate, as every roving wiretap must be approved by a FISA court judge. If a target changes his cell phone and the FBI moves to surveil the new phone, the court is notified of that change. All of the protections for U.S. person information that apply to any other FISA wiretap also applies to roving wiretaps. In short, while this authority is a tremendous asset for the FBI and has been used 140 times over the past 5 years, it poses no additional civil liberties concerns, and it should be renewed without delay. With regard to Section 215, the Business Records Act, over the past several years, the rallying cry against the Patriot Act has centered on Section 215, FISA Business Records Authority. Section 215 allows the FBI to seek FISA court authority to obtain business records such as hotel information or travel records. As with each one of the expiring provisions, the FBI must meet the statutory standard of proof. The Inspector General from the Department of Justice conducted several audits of the FBI's use of Section 215 orders and found no abuses of the authority. Director Mueller testified that the business records sought by the FBI in terrorism investigations are absolutely essential to identifying other persons who may be involved in terrorist activities. The lone wolf provision, the sole expiring provision under the Patriot Act that has not been used by the FBI, prompting some critics to demand its repeal, is the lone wolf definition of an agent of a foreign power. Recent events have demonstrated that self-radicalizing individuals with no clear affiliation to existing terrorist groups are a growing threat to national security. The lone wolf provision provides a counter to that threat, at least in the cases of a non-U.S. person who is readily identifiable with a particular foreign power. The lone wolf provision is a necessary tool that will only need to be used in limited circumstances. It's kind of like those in case of emergency break glass boxes that cover certain fire alarms and equipment. While we may not use it too much, we will certainly wish we had it when the right situation comes up. In conclusion, I am grateful for the leadership of Senators Reid and McConnell on this crucial piece of legislation. This bill will ensure that our intelligence and law enforcement professionals can continue doing what they do best without any additional restrictions. Our nation has been fortunate to have not suffered a sequel to the 9/11 attacks, and much of the credit goes to the dedicated work of our intelligence and law enforcement professionals. We owe them not only our thanks, but the recognition that their jobs are as difficult as it is, and we should not be taking any steps that will make their responsibility to protect this country any more difficult. Mr. President, I urge a vote in support of invoking cloture on the motion to proceed, and I yield the floor and suggest the absence of a quorum.
Clerk will call the roll. Mr. Okaka.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the motion to proceed to S-1038, a bill to extend expiring provisions of the USA Patriot Improvement and Reauthorization Act of 2005 and so forth and for other purposes, signed by 18 senators.
By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on the motion to proceed to S-1038, a bill to extend the expiring provisions of the USA Patriot Improvement and Reauthorization Act of 2005 and the Intelligence Reform and Terrorism Prevention Act of 2004 until June 1, 2015, and for other purposes, shall be brought to a close. The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Balkis. Mr. Begich. Mr. Bennett. Mr. Bingaman. Mr. Blumenthal. Mr. Blunt. Mr. Bozeman. Mrs. Boxer. Mr. Brown of Massachusetts. Mr. Brown of Ohio. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Coates. Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Conrad. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Crapo. Mr. Dement. Mr. Durbin. Mr. Enzi. Mrs. Weinstein. Mr. Franken. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heller. Mr. Hoven. Mrs. Hutchison. Mr. Inhofe. Mr. Inouye. Mr. Isaacson. Mr. Johans. Mr. Johnson of Wisconsin. Mr. Johnson of South Dakota. Mr. Kerry. Mr. Kirk. Ms. Klobuchar. Mr. Cole. Mr. Kyle. Ms. Landrieu. Mr. Lautenberg. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Lieberman. Mr. Lugar. Mr. Manchin. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mrs. Murray. Mr. Nelson of Nebraska. Mr. Nelson of Florida. Mr. Paul. Mr. Portman. Mr. Pryor. Mr. Reed, Rhode Island. Mr. Reed of Nevada. Mr. Risch. Mr. Roberts. Mr. Rockefeller. Mr. Rubio. Mr. Sanders. Mr. Schumer. Mr. Sessions. Mrs. Shaheen. Mr. Shelby. Ms. Snow. Ms. Stabenow. Mr. Tester. Mr. Thune. Mr. Toomey. Mr. Udall of Colorado. Mr. Udall of New Mexico. Mr. Vitter. Mr. Warner. Mr. Warner. Mr. Webb. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Senators voting in the affirmative: Ayotte, Barrasso, Bingaman, Blumenthal, Bozeman, Boxer, Burr, Cardin, Chambliss, Coates, Coburn, Collins, Conrad, Coons, Cornyn, Crapo, Feinstein, Franken, Gillibrand, Grassley, Hagan, Hetch, Hoeven, Inouye, Isaacson, Johans, Johnson of Wisconsin, Johnson of South Dakota, Kerry, Kirk, Klobuchar, Cole, Kyle, Lautenberg, Leahy, Levin, Lugar, Manchin, McConnell, Menendez, Murray, Nelson of Nebraska, Reed of Rhode Island, Reed of Nevada, Schumer, Sessions, Shaheen, Stabenow, Thune, Toomey, Udall of New Mexico, Warner, Webb, Wicker, Wyden. Mr. McCain, aye. Mr. Portman, aye. Mr. Casey, aye. Mr. Roberts, aye. Ms. Snow, aye. Senators voting in the negative: Begich, Heller, Sanders, Tester. Mr. Moran, aye. Mr. Enzi, aye. Ms. Mikulski, aye. Mr. Carper, aye. Mr. Akaka, aye. Mr. Merkley, no. Mrs. Hutchison, aye. Ms. Landrieu. Ms. Landrieu, aye. Ms. Murkowski. Ms. Murkowski, no. Mr. Harkin. Mr. Harkin, aye. Nelson of Florida. Mr. Nelson of Florida, aye. Mr. Lieberman. Mr. Lieberman, aye. Mr. Baucus. Mr. Baucus, no. Mr. Udall of Colorado. Mr. Udall of Colorado, aye. Mr. Rockefeller. Mr. Rockefeller, aye.